Thank you for watching Divorce Nation. On this channel, we discuss marriage and divorce. Hi, my name is Kadosh, and today's topic is how to format emotion. Before we start, I have to give you a disclaimer. What I am about to tell you is for entertainment purpose only. I am not a lawyer and I do not offer legal advice. If you need legal advice, look for a competent and honest attorney. Do not take legal action based on a video you watched on the internet. Before watching this video, please watch the video titled "What is Emotion?" With that being said, there are requirements that should be observed before you send a motion to court, and those prerequisites will be discussed in the next video. Today, we are going to talk about how to draft a motion, but with emphasis in formatting it. Did you know that if you don't format a motion the way it is required, your motion could be rejected by the court? Every day in divorce courts, motions are refused because of technicalities and small mistakes. As you watch our channel, you might find out that sometimes divorce court is more focused on trivialities and small procedures than on the law itself. I'll get back to this point towards the end of the video. Now let's go back to the subject of formatting a motion. Before filing your motion, it is your job to contact the court and ask questions and instructions about how to format your motion. Sometimes the formatting rules change from court to court and from time to time. I'm going to give you 6 obvious questions for you to ask your court clerk in case they don't have a set of instructions to provide you. Question number 1. Can I handwrite my motion? Depending on the court, the answer is probably going to be no. You are probably going to have to typewrite your motion. Number 2, what is the size of the paper that I should use? The answer is probably going to be 8.5 by 11 inches. Number 3, should the motion be double-spaced or single-spaced? In some courts, single-spaced, and others double-spaced. Number 4, what about the footnotes? Am I allowed to add footnotes to the end of the page? The answer varies according to the court. Number 5, what about the margins? Should they be 1 inch on each side? Finally, question number 6. What kind of font should I use and what size? What about the headings and subheadings? Should I use the same kind of font and size? By the way, believe it or not, did you know that your motion could be rejected by the court if you use the wrong font or the incorrect font size? I know from experience because it happened to me once. I followed the instructions and I used the correct font and the correct font size, but I didn't know that the instructions that I used were outdated. Call your court and make sure you are using the most recent set of instructions. Sometimes court assistants are very helpful and proud of the work they do. But sometimes they are not. Occasionally, they are underpaid and overworked. From time to time, when you ask a court assistant a question about formatting a motion, they say, "I can't give you legal advice." Well, you are not asking for legal advice. You are just asking how to format your motion. Sadly, every so often, court assistants are not able or willing to help. Unfortunately, legal advice is extremely expensive. Soon I'll make another video on how you can get legal information for free. Now, I am going to propose to you a scenario that might be very similar to what you might experience every day in divorce courts. Let's say, for example, that your ex-wife finds a boyfriend that is willing to finance her litigation against you. Or maybe her boyfriend helps her to pay her rent, enabling her to have some money left over for litigation. Or even better, maybe she finds a lawyer that is willing to receive favors in exchange for legal work. One day, she decides to send a motion to court, alleging that you don't allow phone conversations between her and her child when the child is in your possession. So, now you have a limited amount of time to answer her motion. An experienced lawyer can answer a motion in just 2 or 3 hours, but someone that is responding to a motion for the first time could take days or even weeks to prepare a proper response to a motion. During your preparation, you do what most people that represent themselves do. You read and research the Constitution. During your research, you find the Sixth Amendment, where it says, "The accused shall enjoy the right to be confronted with the witnesses against him." That finding leads you to a Supreme Court decision from 2004 called Crawford versus Washington, where it reaffirms what the Constitution has said on the Sixth Amendment. Let's say that in our example, your motion was not accepted by the court because it was handwritten, or maybe because you used the incorrect font. Also, the evidence that you attached to your motion in order to support your claims were also rejected altogether with your response. Unfortunately, the hearing is the very next day, and you don't have enough time to prepare another response motion according to the court's rules. Now, let me explain to you what happens on the day of the hearing. During or before the hearing, the judge reads your ex-wife's motion. Also, her lawyer verbally presents her side of the story during her opening statement. And your ex-wife presents her testimony, alleging that you don't facilitate communications between mother and child. During your ex-wife's testimony, she presents to the judge an out-of-court statement to prove the truth of the matter. She says that her child constantly asks you to have a phone call with her mother, but you say no. Immediately you stand up and you say, "Objection, Your Honor, hearsay." For whatever reason, the judge believes that your ex-wife's statement is credible, although the person that gave the statement is not present in court. And the judge says to your hearsay objection, overruled, you cannot believe your ears. In your opinion, the judge made a mistake by accepting the testimony of someone that's not present in court. Now you try a different approach by telling the judge that according to the Sixth Amendment and Crawford versus Washington, you have the right to cross-examine the witness against you. Now you made the judge very, very angry by not accepting her judgment and trying to correct her ruling. The judge responds again, overruled, this is not criminal court and the Sixth Amendment does not apply here. Then you tell the judge, but your honor, I brought to court the carrier phone bill proving that mother and child have regular phone calls with each other when the child is with me. All of a sudden, opposing counsel stands up and says, objection, the evidence that the defendant is trying to present to court was not properly formatted according to the local rules. The judge responds, objection sustained. Now you realize that you have your first and most important lesson in divorce court. You learn that divorce court is not about truth and justice. You learn that divorce court is about what you can present to the court in the day of the judgment. Also, you learned in school that in theory the Constitution is the supreme law of the land, but you found out in divorce courts that in practice parts of the Constitution might not apply to all kinds of courts of law. Unfortunately, during the hearing, you had several things against you. The judge was exposed to your ex-wife's motion, but not yours, plus the declarations of her lawyer, plus your ex-wife's testimony, and plus a statement of your own child that was not present in court. Again, you had several things counting against you in the day of the hearing. I hope you understand the importance of properly formatting your motion according to the rules. In our example, having the judge decide in favor of your ex-wife could have serious emotional, legal, and financial consequences against you. Now that I gave you the questions to ask the clerk of court, go ahead and get your answers. As soon as you receive a motion from the court, find out how many days you have to provide an answer. And never wait until the last minute to file your response to her motion. Before going to the hearing, make sure you understand the confrontation clause, hearsay, and how to object in court. Soon I'll make a new video about those subjects. I hope I have helped. Don't forget to like and subscribe. Please leave a comment, especially if you were a victim of the divorce industry. Most importantly, share this video with your friends, above all, those who are thinking about getting married, or the ones who are going through a divorce right now. Unfortunately, nowadays, divorce is war. Avoid divorce, by not getting married. Thank you for watching.